This video's information is being provided for informational, educational, and general interest purposes only. The information in this video is not intended to shock, enrage, or otherwise provoke the viewer. The sole purpose of this video was to raise awareness of true crime-related events. Copyright disclaimer: under Section 107 of the Copyright Act 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, education, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Non-profit, educational, or personal use tips the balance in favor of fair use.
I've said he was worthless, and yes, I'm angry at him because he falsely arrested me.
Okay. And you're suing him in federal court, correct?
Correct.
And how much money are you suing him for in federal court?
Now, I haven't looked at that case in about 6 months because we're still waiting on a ruling from the judge. Let me double check here.
No, that's all right. I don't think.
What's your emergency?
We are now on the record for the video deposition of Jason Lee Van Dyke. The time is 12:11 p.m. The date is May 28th, 2020. Will counsel please state their appearances and where they are located?
Oh, you want me to start?
Sure.
Okay, I'm Tom Retzloff. I am the plaintiff.
I'm Jason Van Dyke. I'm the respondent, and we're presently located in Frisco, Texas.
We also see a Jeffrey Durrell on. Could he state his appearance, please?
I needed to unmute. My name is Jeffrey Durrell, and I am in Houston, Texas.
And are you counsel in this case, sir?
I'm not counsel in this case. I'm counsel for Mr. Retzloff in another case.
All set.
So I will not be asking any questions or making any objections or speaking after this.
All right, sir, if you can raise your right hand, please. Solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
And as a preliminary matter, I need to make an objection to this deposition due to improper notice. The notice of deposition in this case is for an in-person deposition. Mr. Retzloff is elected to appear remotely in violation of the rules. Although the rules do allow for remote depositions, Rule 199.1b and 199.2b3 of the Texas Rules of Civil Procedure state that a party may take an oral deposition by telephone or other remote electronic means if the party gives reasonable prior written notice of intent to do so. This is not contained in any of the notice or the emails leading up to the notice. I'm introducing this notice of deposition as my Exhibit A in support of my objection, as well as the emails between myself and Mr. Retzloff leading up to this deposition as Exhibits B.
Which is which?
A is the notice, and B collectively are the emails.
You may proceed.
State your name.
Jason Lee Van Dyke.
And you are the respondent in this case, correct?
Yes.
And you have read over the petition or the application for protective order?
Yes, I have, and I have it in front of me.
What are your defenses?
Unclean hands and collateral estoppel are the affirmative defenses. The other defenses are, I did not engage in any type of stalking of you, sir.
Is that it?
Yes.
Okay. You see what I'm showing on the screen?
I do.
And that's it's your second First Amendment answer, filed May the 19th. You previously filed another document called First Amendment answer, correct?
I don't recall. I believe I filed an original answer, and then I believe I filed that document as a First Amendment answer. I've got them on my computer. I'm happy to double check for you.
That's all right. And you understand that this is a proceeding for a protective order pursuant to the Code of Criminal Procedure, Chapter 7?
Chapter 7A, yes.
Okay. And tell me about your affirmative defense of unclean hands.
Well, I'm going by what I've stated in my answer. You've requested equitable relief in the form of a protective order, and unclean hands is available as an affirmative defense in claims for equitable relief.
You're sure about that?
According to my legal research, yes.
Tell me about your legal qualifications.
Well, I don't understand the question. Would you like me to begin with my education, with my experience as an attorney? Can you give me something more specific, please?
Well, I want to know what qualifications you have to render legal opinions. Do you have any specialized training or education in the law?
Yes, I do.
Okay, describe that, please.
After I graduated with my undergraduate Bachelor's of Arts degree from University of Dallas in December of 2003, I attended Stetson University College of Law in Gulfport, Florida from January of 2004 until I graduated in 2006 with a degree of Juris Doctor. I was also awarded Stetson University College of Law's Certificate of Concentration in Advocacy and its William F. Blues Pro Bono Service Award. I was originally licensed in the state of Texas on, I believe it was February the 8th of 2007. I was subsequently, and I don't have the exact dates, licensed in the states of Colorado and Georgia, as well as in Washington, D.C. I was also, after I was admitted in Texas, licensed in all 4 federal courts in Texas, the 5th Circuit Court of Appeals, and the U.S. Supreme Court. I practiced from approximately February of 2007, when I first got my license, until February 29th of 2019, when I was suspended.
And why were you suspended?
For allegedly violating Rule 8.04A2, I believe, of the Texas Disciplinary Rules of Professional Conduct.
And what were the specific allegations against you that caused you to get suspended?
They said that I had made threats against you.
Did they tell you how many threats?
I don't recall how many threats. My recollection of the matter is that they related to email communications sent to an individual named Dean Anderson.
Objection, non-responsive. Do you recall how many threats they told you you had made?
No.
Would it be more than one?
I believe that's what they alleged in their petition, yes.
Would it be more than 5?
I don't recall.
Okay, let me see if I can help. What do you see on your screen?
I see their third amended evidentiary petition filed December 18th, 2018.
All right, this has been previously marked as exhibit number 1.
Okay.
And you recall being served with a copy of this evidentiary petition?
I believe, yes, I was.
Okay. And this was filed by the State Bar of Texas, Commission for Lawyer Discipline, correct?
Yes.
In fact, that's your name right there at the very top of the page here that I'm highlighting in yellow, correct?
Oh, now I see it. Yeah, yes, that is.
All right. There's a bit of a lag. Read what I just highlighted.
The complaint that forms the basis of this disciplinary proceeding was filed by Thomas C. Retzloff.
Okay. You see this heading here on page 2 called Factual Allegations?
I do.
Okay. I want you to start reading that paragraph, please.
Object to form. On or about March 28th, 2018, respondent filed a lawsuit against complainant Thomas C. Retzloff, complainant, in retaliation for Retzloff filing a grievance against respondent. Further, beginning...
Okay, stop. Now, who is the respondent?
That would be me.
Okay. So the very first sentence starts off with the accusation that you filed a lawsuit against me in retaliation for my filing a grievance against you. That's the allegation, correct?
Yes.
Okay. Let's continue reading.
Further, beginning in or around March 2018, respondent repeatedly told complainant to kill himself and made multiple threats of physical violence to Retzloff, thereby committing criminal acts that reflect adversely on respondent's honesty, trustworthiness, or fitness as a lawyer.
All right, let's pause for a moment. You were accused of making multiple threats of violence against me, is that correct?
That's what it says.
And if true, would that adversely reflect on the honesty and trustworthiness or fitness of someone to be a lawyer?
No.
Is it ever appropriate for a lawyer to make threats of physical violence against another person?
Yes.
Under what circumstances?
Well, if it was, for example, immediately necessary for self-defense, if someone was making, for example, a threat of force in response to another's unlawful use of force against that person, it would certainly be appropriate.
Define what an unlawful use of force is.
An unlawful use of force, I don't know how to define that. It would be defined by statute.
Didn't at some point in your life you apply for a job and actually get hired as an assistant district attorney?
Yes, that's correct.
And how many applications did you send out seeking jobs as a prosecutor?
Are you asking with respect to a specific office or to that specific office?
In your entire lifetime, since the date you passed the bar exam, how many applications have you submitted to be an assistant district attorney or to be a prosecutor in any jurisdiction on the planet?
Object to form, and I don't recall.
Would it be more than 10?
Yes.
More than 20?
Yes.
More than 50?
I would say between 20 and 50. It could be more. I do not recall. You are asking me questions dating back 12 or 13 years.
Yes, I am. And we're going to be talking about things that go back even farther than that, so hang on. When you filled out these applications, these 20, 30, 40, 50 applications, at the time you filled out the applications, did you feel personally that you were qualified to be an assistant district attorney or to be a prosecutor in each of those jurisdictions?
Object to form? Yes.
So again, explain what an unlawful use of force is.
An unlawful use of force would be any use of force, the definition of force meaning to compel by physical means or legal requirement against another person. Anything that would be contrary to statute.
So you're talking about a physical threat.
Typically, yes.
What other type of threats would justify, would be considered an unlawful use of force?
Well, a threat to use force in response to another threat for use of force, I suppose.
Okay. And if a lawyer were to improperly make a threat of physical violence, would you agree that that would reflect adversely on that individual's ability to be a lawyer?
No, I would not agree.
You would not agree?
I would not agree.
Why is that? Explain.
Because I don't think an act of that nature has anything to do with a lawyer's honesty or trustworthiness, and fitness is specifically defined by the Texas disciplinary rules of professional conduct as relating to a person's mental capacity to practice law, and I don't think it reflects on that either.
So you think it's totally cool if a lawyer is a violent person who makes violent threats?
Object to form. That's not what I said, Mr. Retzloff. What I said is that it does, in my opinion, it does not violate Rule 8.04A2.
But the State Bar of Texas disagreed with you, correct?
Yes, they did.
And didn't you end up pleading guilty to that State Bar disciplinary petition?
No.
What did you do? How was that case resolved?
I stipulated for the purpose of that proceeding only to the sufficiency of the evidence, simply so that a settlement agreement with respect to agreed discipline could be signed by Mr. Hagan, who was presiding on the panel. I did not admit any misconduct.
So, in your opinion, your stipulation only applies to that little world within the State Bar proceeding, that it doesn't apply anywhere else?
Object to form. The stipulation was as to the legal sufficiency of the evidence for that proceeding only.
And you don't agree that it could be that finding, that agreed suspension, that the findings by that tribunal can be applied elsewhere?
No, I do not.
What is your legal basis for that?
Object to form and object to privilege, work product doctrine.
You're not an attorney, though, are you?
I'm still entitled to my work product.
Okay. go back to our reading. Let's start right down there. I want you to read that sentence for me, please, starting there.
Beginning with the threats.
Correct.
The threats respondent made to the complainant and or criminal acts committed by respondent include but are not limited to the following. 1. Respondent threatened complainant, no more lawsuits, see you this weekend with my rifle. 2.
All right, let's pause for a moment. No more lawsuit, see you this weekend with my rifle. What does that mean? What did that mean when you said that?
Object to form.
What's your answer? What did you mean when you said that?
I'm objecting to the form of the question. It assumes facts that I haven't admitted to.
Okay. Did you make that statement?
To whom?
Well, you pled guilty to the state bar saying you did make that statement.
Object to
right?
No, I did not. I believe I've been very clear on this with you, Mr. Retzloff.
That you admitted that the state bar had enough evidence to prove that you said those things.
No, I said they had enough evidence to impose discipline. I didn't say that they had sufficient evidence to prove that I said any specific thing, Mr. Retzloff.
Okay, well, you still got to answer the question. Even if you object to the form of the question, you still got to answer. It's up to the trial judge to decide whether your objection is legitimate. So what did you mean when you said, no more lawsuit, see you this weekend with my rifle?
I'm going to object to that question on the basis that it is abusive and harassing within the scope of Rule 199.5.
How is it abusive and harassing?
Because by the very nature of the question, Mr. Retzloff, it assumes that I said it to you and that I'm agreeing that I said it to you, and I don't.
I didn't say that you said it to me. Did I?
You've implied it by your questionings.
I'm just asking you to read the document that was filed by the State Bar of Texas in your disciplinary case. That's all. If you choose to read into it something that's not in the document, that's your problem. Now let's go back to this document again.
All right.
Because it's not going away. Number 1, respondent threatened complainant, no more lawsuits, see you this weekend with my rifle. What does that mean?
That is a threat.
Okay. Why would you say such a thing?
Well, the person I said it to at the time, whoever that was, and I don't have personal knowledge of who it was, had just gotten me fired from my job at Carlson, LeBlanc, and Rich.
So it's okay to make threats to a third person as long as you don't make it to the first person. Is that what you're basically trying to say?
Object to the form. I don't understand what you're saying here.
Well, your response seems to imply that, well, because I said that to someone else who might or might not have been Tom Retzloff, it was okay for me to say those things.
I don't know who the person I said it to was, and it's only relevant to this case if I said it to you.
And you base that on what? The relevancy. Where are you getting that from? Why do you think that it would only be relevant under that circumstance?
Because under Texas Penal Code 42.072, the conduct has to be directed towards a specific person. If you're not that specific person, it's not relevant to this case.
Your father's name is Daniel Van Dyke, correct?
Object to form, yes.
If I were to call him on the phone right now and say, Dr. Van Dyke, I'm going to murder your son Jason. Tell him I'll see him this weekend with my rifle. Under your theory, your legal theory, that would be okay?
I'm saying that it would not constitute stalking under Texas Penal Code 42.072. Correct.
What other kind of crimes do you think would apply to such a situation?
Object to form. I don't understand the question.
If I were to call your father up and say, Dr. Van Dyke, tell your son I'll see him this weekend with my rifle. In your 12 years of experience of being a lawyer and in thinking that you're qualified to be a prosecutor, what kind of crimes do you think that might be?
I think that would be telephone harassment of Dr. Van Dyke.
Any other type of crime?
No.
And if Jason Van Dyke were to get a phone call from his father, Daniel, saying, hey, I just got this message from some guy who said, see you this weekend with my rifle, you don't think Jason would have a right to be concerned, afraid?
I might be concerned, but it wouldn't be a crime.
In your opinion?
Correct.
Would you be upset if you had heard such a statement relayed to you by a third party?
I suppose that would depend who it was from.
Earlier in your amended answer, you mentioned an incident involving your mother. Tell me about that.
Okay. It was my mother's birthday, or around that time. I had wished her a happy birthday on my Facebook page. I received an email from a person purporting to be named Dean Anderson, which simply said something to the effect of, so how's your mom? Or how's your mother? I don't recall the precise wording, but it was something to that effect. Knowing that Dean Anderson, whoever he is an administrator of a website known as BV Files, located at www.viaviewfiles.net. I went to that website to determine whether there was any information about my mother on the website, and what I discovered was a portion of the most recent blog post, which had what appeared to be a Third Reich German medal in relation to my mother, a statement stating something to the effect of that my mother should have swallowed me, at which point the post contained a picture of myself, my younger brother, and my mother. It contained information concerning where my mother was employed, and it contained a physical map to my mother's home.
And what's the name of your mother?
Susan Lynn Van Dyke.
Okay. And what did you do once you saw this information on this website that you claim to have seen?
I immediately went to her home. I furnished her a handgun and hollow point ammunition for her own protection. And Pardon?
What type of weapon did you give her?
A Glock 19 9mm pistol.
And how much ammunition?
A full magazine, which would be 15 rounds.
And how old is your mother?
Right now, she would be 70.
And how old was she at the time you gave her this weapon?
Let's see. Be 2018. She'd have been 68.
And you said that this was on or around your mother's birthday.
Correct? It was on her birthday. She was scheduled to go in. I remember because
just answer the question. So what was the date?
April 24th, 2018.
And you have claimed that you took her down to the Frisco Police Department, correct?
I did take her to the Frisco Police Department.
And who did you see when you were at the Frisco Police Department?
There's a person who was working the desk. I explained the situation and asked to speak with an officer. I don't recall the name of the officer, but the officer came out and my mother made a report. I don't recall the name of the officer.
Okay. Because I've contacted the Frisco Police Department and they claim not to have any record. Do you know why that might be?
I have no idea. I'm happy to contact them myself because I distinctly recall taking her there.
Okay. What sort of training does your mother have with firearms?
She has a Texas concealed handgun license.
And how did she obtain such licensing? Who gave her training?
I did.
Okay. And you think you're qualified to teach people how to safely handle and use firearms?
Object to form, yes.
And what was it that you told your mother that got her upset enough to go down to the police station?
I showed her the post. She was familiar with our dispute, and I told her that you were a psychopath.
Okay. So to get back to what we were originally talking about 10 minutes ago, the threat, no more lawsuits, see you this weekend with my rifle, under your reasoning, it doesn't count because it wasn't directed at the person whom you wanted it directed to, which would be me, correct?
I never said I wanted it directed to you. I wanted it directed towards Dean Anderson, whoever that is.
All right, let's start with number 2 here. Read that, please.
Respondent threatened complainant, if you do not stop calling my clients, I will make you suffer. Better watch your back, Tom.
Okay, and did you say those words?
Yes.
Okay, and why?
I wanted to make it clear that if you kept contacting my clients, there were going to be serious legal consequences for you.
Not threats of violence, though, apparently, right?
I did not mean that as a threat of violence, no.
But the state bar apparently disagreed, correct?
They must have, yes.
Let's start with number 3 then. Read that, please.
Sir, I need you to switch to the screen so I can see it, please.
Oh, fuck. All right, there we go. Number 3, please.
It says, respondent threatened complainant, did you know that when I strangle you, you could be unconscious to feel all of that pain for up to 3 minutes before brain death occurs? What type of vegetable would you like to be for the rest of your life? How about a turnip?
Okay, let's pause for a moment and think about that. That right there is a statement of physical violence, correct?
That's not a threat to do anything. It's a statement of, it's merely a statement. It's not a threat to do anything, and it was directed towards Dean Anderson, whoever that is.
That's your answer?
Yes.
Okay. Have you ever strangled anybody before?
Yes.
You have. Describe the circumstances, please.
I'm a brown belt in judo and a purple belt in Brazilian jiu-jitsu, and I used to compete regularly. And in both sports, choke holds, which are defined as air pipe chokes, or strangle holds, which are defined as holds with respect to the 2 arteries that provide blood flow to the brain, are legal techniques for those types of events.
Okay, and how long have you been engaged in the martial arts? Training in it? When did you first start?
When I was about 12 or 13.
And you've been doing that since then?
On and off.
And how old are you today?
40.
Okay. Are you any good at it?
Not really.
Have you ever won any trophies or awards?
Yes, I have.
For what?
I've won medals in my weight and age division for Brazilian Jiu-Jitsu at the NAGA, that's NAGA, grappling tournaments, as well as a few other tournaments by International Brazilian Jiu-Jitsu Federation, and there were a couple other smaller ones. I don't recall the names at the time. They were very small tournaments.
Okay, that's fine. Outside of your martial arts practicing or training, outside of a dojo, outside of the ring, have you ever engaged in any acts of physical violence since you were 18?
Yes.
Describe that.
One of them, to the best of my recollection, is a person attempted to mug me, and I punched them, and they ran away.
Where was this?
That was in Washington, D.C. I was 20 or 21. I don't recall when.
Okay.
Let's see. At one point, I was jumped by some individuals playing something that's apparently called the knockout game, and I defended myself. I defended myself physically in that situation.
When? When did this happen?
I don't recall exactly. It was probably 8 years ago, give or take.
Where at? Where at?
It was in downtown Dallas.
And who were you with when this took place?
I was alone.
Tell me about the next instance.
The next incident was in March of, I believe, 2018 in Austin, Texas, where me and some gentlemen I was with were jumped outside of a bar.
And who were these people you were with?
They were my fraternity brothers.
Names?
Object to form. Privileged. I used to represent this fraternity, and I object pursuant to the attorney-client privilege to name any member of the fraternity.
Have you ever represented these specific individuals that you were with?
No, but I've represented the fraternity as a whole and the chapter as a whole.
You understand that the attorney-client privilege doesn't apply to the names of clients.
I'm not going to give you their names. You can file a motion to compel if you want. I'm not giving you their names.
Okay. And what is your basis for not wanting to give me their names?
Well, 3. 1, it's an abusive and harassing question, which has well outside the scope of discovery in this case. 2, attorney-client privilege. And 3, because I don't want their names to end up on the viaviewfiles.net website.
You understand that you're on trial here because somebody has deemed you to be a threat, a violent lunatic. You understand that that's what this case is about, right?
Object to form. I understand what the case is about.
Earlier you had mentioned, well, never mind. We'll get back to that. Let's look at number 4 here. Read me number 4.
Respondent threatened complainant, LOL, you are a dead man, enjoy it while it lasts.
Okay. You are a dead man. That sounds like a murder threat, doesn't it?
No.
What is it then?
That's hyperbole.
It is?
I think so, yes. That is not a reasonably specific threat to do anything at a reasonably specific time.
You understand that I used to be a former federal and state law enforcement officer.
Object to form. No, I don't understand that.
I've locked up people for less than that.
Is that a question, Mr. Retzloff? I'm objecting on the basis that that's abusive.
Let's ask a question then. Were you arrested for obstruction of justice and retaliation against a witness by the Oak Point, Texas Police Department?
The charge was obstruction or retaliation, and the answer is yes.
And what were the allegations?
The allegations were that I supposedly sent you 2 emails containing threats on or around December 12th of 2018.
And those emails said what?
I don't recall. I didn't send the emails.
You've never seen these emails before in any of the court documents in 2 years?
I've seen them. Mr. Retzloff, you're asking me to quote these emails specifically. I'm telling you I can't recall exactly what they said, even though I've seen them before.
Okay. You'll get a chance to.
No doubt.
Let's start with number 5. Please read that.
Respondent threatened complainant, I can't wait to see your fat ass on the other end of my scope. Did you know that a 190 grain 300 Winchester Magnum travels at approximately 2,800 feet per second?
Okay. Let's pause there for a moment and think about that. Is that an accurate statement with regards to the capabilities of a 300 Winchester Magnum?
It is.
And how do you know that it is?
Because I'm familiar with the ballistics of a 300 Winchester Magnum.
Do you own a 300 Winchester Magnum?
Object to form. I'm not answering any questions about my ownership of any specific weapon. I am not presently in possession of any firearms.
Objection non-responsive. Have you ever owned a 300 Winchester Magnum?
Object to form. I am not answering any questions about my ownership of any firearms. This question is abusive. Now you can restrict your questions to the scope of discovery, or I'll suspend this deposition.
You understand that if you walk away from this, that I'm going to ask the court to strike your pleadings, and they'll give me that protective order and a lifetime ban on your firearm ownership.
Object to the form of the question, abusive and harassing.
In your experience as a lawyer, what are the consequences for someone who has failed to attend a deposition?
Object to form, abusive and harassing.
You still have to answer the question, though, right?
I've not personally dealt with the issue of someone refusing to attend a deposition except in one instance, and unfortunately, if I recall in that case, the person who failed to attend a deposition removed the case to federal court, so the motion for sanctions I had filed never got to be heard.
Okay, but one of the sanctions for failing to attend a deposition is your pleadings can be struck and a default judgment, correct?
Not typically. Typically, the Texas Supreme Court, before what are called death penalty sanctions, can be administered.
Objection is...
Mr. Retzloff, you're asking about what my experience is, and I'm telling you.
Okay, all right. So you're not, your claim is that any questions about firearm ownership, you're not going to respond to. Is that correct?
That is correct.
And the basis for your refusing to answer that is you think that it doesn't apply to this case?
The rules of discovery are set forth in Rule 192.3. The question of what they are outside the scope of discovery. This deposition, Mr. Retzloff, is based upon the allegations contained in your pleadings and my pleadings.
And I'm also allowed to ask questions that will lead to the discovery of relevant information, correct?
That is correct. Whether I have ever owned a firearm is not relevant to this case.
I'm asking you about a specific firearm, a 300 caliber Winchester Magnum.
There's no such thing as a 300 caliber Winchester Magnum.
What caliber is that bullet?
That's a .30 caliber.
30 caliber. Okay, well, you got it listed on here as a 300 Winchester Magnum.
That's what the round is called, but it is not a 300 caliber. It is a .30 caliber round.
And how many times have you fired a 300 Winchester Magnum rifle?
I don't recall specifically. I would say over 1,000 times, less than 2,000 times.
Are you proficient with its use?
Object to form? Yes.
I can't wait to see your fat ass on the other end of my scope. Is that not? Could we not agree that that's a pretty threatening statement?
If I said it to you, yes. I'm not saying that I said it to you.
Would it be a threatening statement if you said it to anybody?
Yes.
Read number 6, please.
Respondent threatened complainant, "What do you want on your polished rock, Tom? I'm coming for you. Sure as God's vengeance, I'm coming. Nobody will ever be harassed by you again. You're taking a dirt nap."
And what does that phrase mean, taking a dirt nap?
Means you're sleeping forever 6 feet underground.
That means that the person's going to be dead, correct?
Yes, it does.
And would you not agree that that's a threat of violence?
If I said it, it would have been.
Or do you deny saying it?
I deny saying it to you. I have no idea whether I said it to you.
Read it again.
Respondent threatened complainant, "What do you want on your polished rock, Tom? I'm coming for you. Sure as vengeance, I'm coming. Nobody will ever be harassed by you again. You're taking a dirt nap."
So that's you saying to me, I'm coming for you.
That would depend on whether you're Dean Anderson or not.
That's not a message to Dean Anderson. Dean Anderson isn't even mentioned in there, is he?
The question is whether he's Dean Anderson. If it was sent to a third party, it's not. It's meaningless.
Except that's not what it says, though. It says Tom. It says, "What do you want on your polished rock, Tom?" Correct?
That's what it says.
So that's a message to Tom, correct?
If it was never sent to him, it doesn't matter. What if I wrote that in my diary? Is that still a threat to Tom?
Are you claiming that you wrote this in your diary?
No, I'm offering a hypothetical.
Okay. I'm not asking hypotheticals, Jason.
Okay.
This is a message that you sent this message to somebody, correct?
I don't recall if I sent it or not. It looks like something I might have said right after I got fired. I don't recall when I sent it.
The State Bar of Texas accused you of sending that message to me, correct?
Yes, they did.
And you pled guilty.
No, I did not.
Disciplinary element. What did you plead to then?
I'm going to be very clear on this for the third time now. All I did is I stated that I stipulated that there was legally sufficient evidence to prove a violation of Rule 8.04A2. I did not admit to sending any of those threats to you.
Is this to someone else named Tom that you threatened to murder?
The question is where they were sent to.
No.
I have no personal knowledge of whether they were sent to you, and I cannot answer the question.
Have you ever sent, is there someone else named Tom that you have ever threatened to murder?
Not that I recall.
Do you threaten a lot of people with murder and violence?
No.
How many people have you made such threats to?
Object to form. Mr. Retzloff, that is an abusive and harassing question. I'm not going to answer it. I've told you a number of times to please confine your questions to items within the scope of discovery. I'm not going to go back 20 years or whatever to try to figure out the answer to all these questions.
You're the one that's on trial here. This case is about you making threats. This case is about you plotting an assassination. Correct?
This case is about you allegedly being a victim of stalking as the term is defined in Texas Penal Code 42.072.
I understand that you like to think of yourself as a brilliant litigator, and I see you're trying to parse these words down. But this case, one of the allegations in this case, is it not an allegation that you have plotted with individuals to assassinate myself and my lawyer?
That is one of the allegations in the case.
So is there anyone else named Tom that you have threatened to murder?
Not that there's nobody named Tom that I've made a credible threat to murder.
I'm not asking a credible threat.
I don't recall anyone named Tom who I've made a threat to murder.
Okay. How about other people that you've threatened? How many other people have you threatened violence with in the last 5 years?
Objection form. I'm not answering that for the same reasons I've told you. You're asking abusive and harassing questions that are outside the scope of this case. I'm not going to answer that. And if you keep answering those questions, I'm going to suspend this deposition.
I'm going to ask the court reporter to certify that question for the judge.
Very well.
Have you made threats of violence against a man named Ken White?
Objection, outside the scope, harass and abusive. I'm not answering the question.
Why do you believe that it's outside of the scope? This case is about your threats and about whether or not you are threatened.
This case is about threats supposedly made to you, not to Ken White. It is well outside the scope of discovery, and I'm not answering the question. Next question, please.
So you think that whether or not you've made threats to other people would be irrelevant to the court deciding whether or not to order a lifetime order of protection against you?
Yes, because they're not related to you.
And it's your opinion that only things that are related specific to me are relevant?
That is correct.
Okay. But you still got to answer the question in the deposition, and it's up to the judge to decide.
Well, unfortunately, Mr. Retzloff, you've moved to recuse our judge, so we don't have one to call right now, do we?
Govern yourself accordingly. How about Astor Langdon? Is this an individual that you've made threats of violence to?
Same basic question, same answer. I'm not answering an abusive and harassing question.
Who is Dr. Daniel? Who is Dr. Ryan Daniel?
He's a nutcase dentist who I think practices in Flower Mound somewhere.
And you had filed a lawsuit against him, correct?
No.
You didn't file a lawsuit against him on behalf of some other lady?
Oh, I filed on behalf of another lady, but I didn't personally sue him, no.
Okay. And did Dr. Daniel accuse you of making threats against him?
No, he did not.
Did Dr. Daniel file a state bar grievance against you?
Yes, he did.
And what were the allegations in that state bar grievance?
I don't recall all of them. There were about 10, but I can let me pull it up.
That's okay. I got it right here. I'm showing you what's been marked as exhibit number 3. It's on your screen.
Okay, there you go.
So what is exhibit number 3? Tell me what it says.
That appears to be a copy of the evidentiary petition, a request for disclosure, Commission for Lawyer Discipline versus Jason Van Dyke, related to well, I can't see. I'm assuming, based on the fact that you've pulled it up, that it relates to Dr. Daniel. Yes, it does. I can see that it's highlighted. Yes, I see it, Mr. Retzloff.
Okay. Read the highlighted portion on page 2 of exhibit number 3, please. Read it out loud.
Okay. Throughout the lawsuit filed against Daniel, respondent engaged in activity that unreasonably increased the costs or burden of the case, unreasonably delayed resolution of the matter, served no substantial purpose other than to embarrass, delay, or burden Daniel, presented or threatened to present criminal or disciplinary charges solely to gain an advantage in a civil matter and to prevent Daniel's participation and involve dishonesty, fraud, deceit, or misrepresentations. These actions include, but are not limited to, respondent ceasing settlement negotiations due to Daniel filing a grievance against respondent, respondent advising his client to either cease settlement negotiations or demand an unreasonable amount of money, filing a motion for sanctions against Daniel, misrepresenting or withholding facts to the court, threatening criminal charges and filing a police report against Daniel, threatening to file a grievance against Daniel's attorney, Lauren Harris, and by posting a negative review on Daniel's business website.
And did you file a grievance against Lauren Harris?
I did not.
Did you post a negative review on Dr. Daniel's business website?
Yes, I did.
And did you not plead guilty to this disciplinary?
Mr. Retzloff, there are no guilty pleas in disciplinary cases.
Well, in essence, you pled out. That would be a layman's term.
I settled the case, yes. I settled the case, and I did not admit to everything that's contained in that petition. I'm sure you have a copy of the disciplinary judgment.
And these are the rules that you were accused of violating here on page 3.
That is correct.
That I'm showing you right now. I'm showing you exhibit number 4. Can you see it?
Yes, I can.
What is it?
That's the agreed judgment of fully probated suspension related to the Ryan Daniel case.
The section here, findings of fact. Read what I just highlighted.
Petitioner and respondent agree to the following findings of fact. Accordingly, the evidentiary panel finds.
All right. Read number 4.
Respondent threatened to present criminal or disciplinary charges solely to gain advantage in connection with the civil matter.
And again, you agreed to that finding of fact, correct?
That one I agreed to because I did do that, yes.
And if we scroll down here to the very last page, that's your signature, correct?
Yes, it is.
And you were represented by counsel?
Yes, I was.
Alan Pegg.
That is correct.
I'm just playing around here on my computer. Hold on. All right, let's go back to exhibit number 1. Read number 7.
Respondent threatened complainant, you better have your will made out, Thomas. I'm SIC coming for you.
You said that, correct?
It may have been in an email. I don't recall when or if I said that specifically.
So when you tell me to make out my will, I'm coming for you, Is that not a threat of violence or death?
Potentially. Again, I don't know who it was. I don't recall who it was sent to. I don't recall sending any emails to you containing these threats on or around that time. I recall them being sent to a person by the name of Dean Anderson, and I don't know who that is.
Okay, but that's not what we're talking about here. This says, you had better have your will made out, Thomas. I'm coming for you. That's the words. Correct?
Those are the words. That's what the allegation says.
And again, you aren't making, there's no other person named Thomas that you've made these threats to, is there?
Not that I recall.
Okay. Let's look at number 8. Read number 8, please.
Respondent threatened complainant, you are a dead man.
That sounds like a threat of violence or murder, does it not?
No.
No. It doesn't?
No, it doesn't.
Okay, let me make sure I'm reading the correct document here, because sometimes, you know, I've never done this before, so sometimes I might have clicked on something different, and maybe you were looking at a completely different document than the one I was looking at. So number 8, read that again, please, so I can make sure that we got the right one.
It says, respondent threatened complainant, you are a dead man.
And that's not a murder threat, in your opinion?
No, it's not. I do not believe it meets the criteria for a threat.
Okay. So what does that mean then? What does that mean when it says when somebody says you're a dead man?
I think that can mean anything. That can mean I'm gonna beat you in court. You're a dead man. I'm gonna whip your butt in court, or for example. I'm not saying that to you, but that's an example. It is completely hyperbolic. It does not meet the criteria for a true threat.
Well, one of the criteria for determining whether something is a true threat is context. Can we agree on that? That context is important?
I suppose so.
Let's continue.
Okay.
Read what I just highlighted.
In addition, on or around November 2018, after the evidentiary petition was filed in this matter, respondent again sent a death threat and/or statement intended to harass, annoy, alarm, abuse, torment, embarrass, or offend via social media to complainant, in which respondent posted a picture of himself with a gun, directing his post at the complainant.
You do that a lot, don't you? Post pictures of yourself on social media with various types of firearms.
I have in the past, but not lately, yes.
How many times in the past have you posted photographs of yourself with firearms, do you think?
More than 50, less than 100? I really have no idea.
Have you ever posted a picture of yourself holding a .300 Magnum Winchester?
Yes.
Let's continue on. Read that for me, please.
It says, further, on or about December 12th, 2018, respondent again made multiple death threats to complainant, including but not limited to the following. 1. Respondent threatened, and I quote, "Go fuck yourself and what's left of your miserable life. You have destroyed my life, and for that offense you will pay with your own. That's not a threat, that's a promise, motherfucker." You want me to continue?
Okay.
You want me to continue?
Well, let's pause for a second, because that's pretty wild.
Yeah, it sure is.
Why would you say such a thing?
I didn't say such a thing.
You're denying sending that email?
I am?
The language used in that email, can we agree that that's a very threatening statement?
Oh, yes, I certainly agree with you there. Problem is, I didn't send it.
Okay. Read number 2.
Respondent threatened complainant. I promise you this, motherfucker. If my law career dies, you die with it.
And is that a threatening statement?
It certainly is. Unfortunately, I didn't send it.
Who did?
I have no idea who did. I have no idea whether it was sent by anyone at all, Mr. Retzloff.
What do you mean?
I mean, I have no idea whether it was forged by you, whether someone accessed my computer without permission and sent it. I have no idea as to the origins of that email. All I can testify to, based on my personal knowledge, is that I didn't send it.
So you believe that that email could be a forgery?
Absolutely.
By me?
Yes.
Or you believe that someone else could have had access to your computer and sent that?
Yes, I definitely believe that's possible.
And where was your computer at when this email was sent?
Well, I had two. Which computer are we talking about?
I don't know. You tell me.
Well, I had one computer that was in an open workspace. There was an office off the side that I used, but the door was always unlocked because they used it for other reasons. That was located in my office at White Jacobs and Associates in Plano. And then I had a home computer, which at the time was located at my home on 108 Durango Drive. Again, my home at the time in Crossroads, Texas, 76227. Now, the home computer had software on it which allowed me to access my office computer from home.
Okay. What does that mean? That software that allows you to access your office computer from home.
I think it was called PC Anywhere. I'm not certain.
Is that like some kind of virtual private network or something like that, or secure connection?
Mr. Retzloff, I don't know what a virtual private network is. What it does is, if I was on this computer here right in front of me, it would create an internet connection with my computer somewhere else and allow me to access programs and content on the computer that's somewhere else as though it was this computer right here. And I know that I was not the only person who had access to that home computer at the time.
Who had access to that home computer?
Isaac Markwart had access to it.
And why is it that Isaac would have had access to your computer?
He was living with me on and off at the time, and the computer was located in my home office, which was not separately locked.
And is this a computer that you would use for your legal work as an attorney?
On occasion, I would usually use the office computer, but I did work from home every so often.
Did you not have a password on this computer?
I had a four-digit PIN, but I never thought he would use my computer because he had his own computer.
Is this the same computer that was seized by the Oak Point, Texas Police Department?
It was.
Do you have reason to believe that Isaac Markwart was able to know what your PIN number is and gain access to this computer?
I do now, yes.
What is your basis for that?
Because based upon the public information requests that you and I both sent to the Oak Point Police Department, the one of the documents contained the PIN number.
It did?
Yes, it did. I can look for it. I've got those documents on my computer somewhere. It said PIN, and it had the PIN number that was at the time was used to access that computer.
And that wasn't the number for the alarm code for your house?
I don't recall what the alarm code was at the time. It might have been the same. It might have been different.
What was the alarm code for your house at that time?
To the best of my recollection, it was 2527.
And what's the password for your computer at that time?
I don't recall what the password was, but it would have been that PIN, or it would have been some other PIN, which I'm not going to disclose to you because it's the PIN I'm using now.
And you've looked at the documents from the Oak Point, Texas Police Department where you claim that this PIN number is written down now, you said.
Yeah, let me see if I can find them.
Please do so.
Okay. What records received from Oak Point? Well, might take a minute. I'm kind of looking for a needle in a haystack.
I've got nothing to do today. So take as much time as you need.
It's too bad. I was hoping to go to Topgolf later.
That place sucks. It's not even real golf. They won't let you bring your own clubs there. You got to use their clubs, and they purposefully deaden the ball so you can't even hit it.
Yeah, right here. Let me rotate it. It's on about the 30th page of the total number of documents I received. It's on what appears to be a lined piece of paper, like just a ruled piece of paper, and written in Sharpie in handwriting, which is not my own. It says passwords, door and computer, and they're both black, and they're both blacked out in what they sent to me. And let's see.
Whose handwriting is that?
I don't know. I have no idea whose handwriting that is.
Okay. Tell me more about Isaac Markwart. How old is he?
I believe he's 20 right now.
And at the time, how old was Isaac?
Either 18 or 19. His birthday's in January, and I don't know exactly when his birthday is or when this was issued.
Are you guys related to one another by family?
No, we're not.
And how old are you?
I'm 40.
So why would a 40-year-old guy have an 18-year-old boy living in his house that's not related to him?
He was a roommate. I needed money for to go hunting.
Was there anything more to the relationship?
Object to form. No.
Okay.
Here it is. I've got another thing with a password on it, Mr. Retzloff. It's on a thing that says City of Oak Point, Department of Public Safety Evidence Report. They forgot to black it out. It has a case number, and it says a black Acer laptop, and it has the password written right here at the bottom. I have it right.
What is that password?
It was 2527.
And it's your position that Isaac Markwart could have gotten a hold of your computer and at home and sent that email?
Yes, at someone's, and I believe it was done at somebody's direction.
Really? Whose direction?
I believe it was done at it was possibly done at your direction. I have no personal knowledge, but I have an email which suggests that may have been the case.
An email from whom?
It is an email from that was sent on the same day these emails were allegedly sent to you by me, December the 12th, from a person, Sam Benneth 204. I forgot what mail it was in, where he specifically offered you damaging information on me.
Okay, I'm still not seeing what sort of evidence supports your claim that Isaac Markwart was working for me or under my control.
Well, I've also got affidavits from him invoking his Fifth Amendment privilege with respect to any relationship he may have had with you. Now, again, I don't have personal knowledge that you influenced him or that he was working for you. All I've got is potential circumstantial evidence, and I've reached my own conclusions based on that circumstantial evidence.
And these were affidavits that you submitted to the state bar in response to their disciplinary petition, correct?
They were submitted to the state bar and to the district attorney's office, but I didn't submit them. I believe Mr. Markwart submitted them on his own.
And you're currently on criminal probation right now, correct?
Correct.
And what are you on probation for?
False report to a police officer.
And what are the allegations?
The allegations are that I lied about the occurrence of a burglary of my motor vehicle where several firearms were stolen.
Okay. And these affidavits that were supposedly written by Isaac Markwart, who drafted those documents for him?
I don't know.
Did you?
No.
Did you have any input at all into those two affidavits?
I may have had some with respect to the second one. I got a call from someone claiming to be his attorney. I don't know who it was.
Describe the conversation.
He asked who you were because he was unsure as to the purpose of the affidavit, and he asked at what point Mr. Markwart stopped living with me, and I told him. And he asked at what point I could no longer reach Mr. Markwart when he left the jurisdiction of Denton County, and I told him. It was basically questions like that. It wasn't anything else. He wanted to confirm some dates with me.
And you don't remember the name of this individual who called you?
No, I spoke to him one time almost a year ago.
Did you make any notes of that conversation?
No, it was only confirming dates. It didn't seem to be particularly important to me.
So other than that one telephone call, your position, your statement is that you had absolutely no input into the drafting of those two affidavits.
Into the drafting? No.
How about into the language used in those affidavits?
Into the language used? No.
Did you have any conversations with Isaac about those two affidavits?
Yes, I did.
How many conversations?
2 or 3.
Describe these 2 or 3 conversations.
The first, I believe, was in May of 2019. I hadn't seen him in months. He apologized for not showing up for to court and wanted to know if there was anything he could do to make things right. And I explained to him what was going on in my life, and I told him that an affidavit clarifying what actually happened would be helpful, especially with respect to the burglary. He told me he couldn't do that because then he'd get into trouble. He asked me to draft an affidavit for him. I told him I couldn't because I was suspended and it would be a conflict of interest, and said, you can look up how to do this online or you can go find an attorney to do it for you. And a couple days later, he furnished me by email an affidavit which he appeared to have drafted himself, based on the number of spelling errors and double negatives and things like that. It was not a very good affidavit.
And you helped him clean it up?
No, I didn't help him clean it up. That would have been unethical. I submitted it as it was. That would have been in May of 2019.
Okay. And what about your other second conversation with Isaac about these affidavits?
I met with him at some point in, I believe it was July or August. Again, I don't recall the specific dates. He asked if the first affidavit had helped me at all. I told him it hadn't, because I said it was very vague. It was not specific enough. It doesn't really state how you have personal knowledge of certain things. Again, and then it still doesn't address this problem with this actual burglary. And I said, you really need, if you want to help me, you need to talk to an attorney. I can't help you with this. It would be a conflict of interest. And then a couple weeks later, that's when I think I got the phone call from the attorney. And then he asked if I wanted the affidavits to submit to people, and I told him no. I said, I'm not submitting anything I get from you. If you want to submit these to people, you do that yourself. And he asked for the addresses for the various state bar associations, for the DA's office, and for Mr. Dominic Marsala, and I provided that information to him.
You provided that information to this attorney who was calling on behalf of Isaac?
No, the attorney didn't ask for that. Mr. Markwart asked for the addresses.
Okay, so you told Isaac this is who you need to send this stuff to?
No, he asked for addresses, and I provided him the address. I didn't tell him to send it to anyone in specific. He asked me for the address to the DA's office, the address to my lawyer, and the address to all 4 bar associations, and I gave it to him.
Has Isaac ever been a member of the Proud Boys group?
Objection privileged.
How is it privileged?
I was the attorney for the group. Membership in the group is confidential.
Under what basis is it confidential?
Under the bylaws of the organization. I am not permitted as to disclose the names of any member of the organization or prior member of the organization.
I will ask the court reporter to certify that question.
That's fine.
Were you aware at this time period that Isaac Markwart was acting as an informant for the FBI?
I was not. I don't know if he was ever acting as an informant for the FBI.
When did you find out that Isaac Markwart was acting as an informant for the FBI?
Mr. Retzloff, I don't know if he was acting as an informant for the FBI or not. If he was he might have shared information with them, but that doesn't make him a confidential informant. If you worked in federal law enforcement, you would know this. I have no personal knowledge as to whether he was a confidential informant.
That's not the question. I'm asking you, when did you find out that Isaac Markwart was acting as an informant for the FBI?
The first time I learned that he was acting, that he had made some type of report with the FBI, I do not know if he was an informant, was after I was released from jail in January of 2019.
And who told you this?
He did.
What did he say?
He mentioned that he had talked that while I was in jail and he was looking after my pets, that the FBI had talked to him about me and that he thought I was in really big trouble. I asked him if he had spoken to the FBI about me. He stated that he had, and I told him that I needed him to not be around me anymore.
That the FBI had come to your house while you were in jail?
He didn't say that. He said he had met with the FBI. He did not state that they had come to my house.
And who did he say he met with that were FBI agents?
He didn't mention any names. He said there was a man and a woman.
Okay. And what was your reaction to this revelation?
I changed the locks on my house so that he could no longer access my property.
Okay. I'm showing you what's been marked as exhibit number 2. Can you see it?
It's a little fuzzy. Can you zoom in a little bit, please?
Absolutely. How's that?
Hold on, there's some lag time. All right, that's better, thank you.
All right. Can you read it?
Agreed judgment of partially probated suspension. Is that what you want me to read?
No, I just asked you if you could read it.
Oh, I'm sorry. Yes, I can read it.
Okay. And this is a judgment between yourself and the State Bar of Texas, an agreed judgment.
The
correct?
Commission for Lawyer Discipline. Yes, sir.
Okay. This part here that I've highlighted, read that out, please.
Petitioner and respondent agree to the following findings of fact. Accordingly, the evidentiary panel finds.
And read number 3.
There is legally sufficient evidence to prove by a preponderance of the evidence that on or about March 1st, 2018, respondent made threats of physical violence to complainant Thomas C. Retzloff, thereby committing criminal acts that reflect adversely on respondent's honesty, trustworthiness, or fitness as a lawyer.
And you agreed to that finding of fact, correct?
I agree to the sufficiency of the evidence, yes.
Okay. And let's see. You got suspended for what, 12 months?
Yes.
And have you, you were ordered to pay a fine or some expenses, $7,500, correct?
Correct.
And have you paid that?
No.
Why not?
Well, at first I didn't pay it because there was another case pending with respect to the false report allegations, and I figured if they were going to disbar me in that case, I wasn't going to pay them the $7,500.
And you still haven't paid it, correct?
No, I have not.
What does number 2 there say?
I'm sorry, it's getting hazy again, Mr. Retzloff. I think there's some lag on your end. I think it says respondent. There it is. Respondent shall seek mental health treatment.
And did you seek mental health treatment?
I did. I had been seeing someone prior to that, as a matter of fact.
Okay. I'm scrolling down to the very bottom of this document, page 8. That's your signature there?
Yes, it is.
And you were represented by a lawyer,
Yes, I was.
Alan Taggart?
Yes.
Okay. I'm showing you what's been marked as exhibit number 3. Can you see it?
Not yet. It's still loading. Now I can see it. Now it keeps fading in and out, Mr. Retzloff, but I know what it is. Now I can see it just fine.
Okay. What is it?
It's an arrest warrant.
For who?
For me.
And that would be for the felonies of obstruction or retaliation?
That's correct.
This part here that I'm highlighting. Read that out loud.
The defendant is an attorney licensed to practice law in the state of Texas. Tom Retzloff filed a grievance against the defendant with the State Bar of Texas in December 2017. Accordingly, Tom Retzloff is a witness or prospective witness in a case scheduled to go before the Texas State Bar regarding defendant's law license. Ms. Kristen Brady is Assistant Disciplinary Counsel to the State Bar assigned to the proceeding against the defendant.
Okay. And that's on page 2 of exhibit 3. Do you agree with that statement?
I don't right now, but at the time I would have agreed with it, yes.
Why don't you agree with it now?
Because right now you're not a witness or prospective witness against me for any type of state bar case.
You understand that there's a state bar disciplinary proceeding pending in Washington, D.C.
I'm
Right?
talking about Texas. I'm aware of the one in Washington, D.C., but in Texas there's nothing pending.
You didn't hear me mention the word Texas, did you?
I apologize. I misconstrued your question, Mr. Retzloff.
So we do have a state bar or a disciplinary proceeding pending in Washington, D.C. involving yourself regarding a complaint I filed, correct?
That is correct.
And how about the state of Georgia?
Yes, that one is pending as well.
Okay. Is it ever okay to threaten a witness?
No.
I'll agree with you there.
Mr. Retzlaff, this is the court reporter. When convenient, could we take a quick break, please?
I guess you might as well just take one right now.
Thank
I was
you.
just getting warmed up though, but that's okay.
We're
How long
on.
do you want to take a break for?
Just a restroom break, 5-10 minutes.
Okay, I suppose I can use that to make sure my kids haven't drowned in the pool, but they're with somebody, so whatever.
We're off the record at 141. We are on the record at 152.
Alrighty. I'm showing you what's been marked as exhibit number 5. Can you see it?
Yes, I can.
What is it?
That's a copy of a plea agreement in the false report case.
That's your name on the top, right? You're the defendant?
That's correct.
Okay. You see on the bottom here where it's highlighted?
Yes, I see that.
What does that say?
Have no contact with Tom Retzloff.
And who else?
Deb Armentor.
And who is Deb Armentor?
She is a Denton City Councilwoman and I believe a professor of English and Women's Studies at the University of North Texas.
And she has claimed that you have made threats against her, correct?
I have no idea if she's claimed that or not.
You haven't been told by anybody that there's been this accusation made?
I've been told by people that she claims that she's scared of me, but I don't know if she's ever told anyone that I made a threat against her because I didn't.
Did you ever post her personal information, name, address, similar things on a website?
Not that I can recall, no.
Not that you can recall? Would there have been times when you've done this when you can't recall?
I seriously doubt it. I wouldn't post her. Aside from referencing her by name, I wouldn't have posted her address or her phone number or anything like that. I certainly didn't do that.
How about any information about her on a website that some people would claim is a white supremacist website?
Nope, never did anything of the sort.
Have you ever posted on the Stormfront website?
No,
Never.
not that I can recall. I'm familiar with it. I've read parts of it, but I've never posted there. I don't have an account there.
Have you ever had an account with Stormfront?
No.
You know the man who owns that website?
I have no idea who owns that website.
He lives in North Carolina. He keeps good records.
Okay, I don't know who he is.
So if your name or your email address or an IP address that might have been associated with you at some time in the past were to show up in his records, what would you have to say about that?
I would have no idea how it got there.
And you've never posted on Stormfront?
I don't recall ever posting on that website. I viewed it because I was accused of posting on there at one time, and I wanted to see if I could find the posts that were being referenced by other people, but I don't recall any other time where I've posted on there.
Okay. So why do you think Deb's name was listed on your criminal probation as a person not to have any contact with?
Because she made certain allegations concerning me in a very public manner, and I made an extremely rude and vulgar Facebook post about, with respect to her to answer those allegations.
What allegations did she make about you?
I believe she, in a letter to an administrator at the University of North Texas, she referred to me as a Nazi approximately 34 times.
Okay, so?
I don't tolerate that kind of behavior from anyone.
And your response when people exhibit that type of behavior is what?
I retaliate.
You don't believe in the right of free speech?
No, I do not.
And your response when people criticize you or say things about you that you don't like is to retaliate?
Yes, in a legal manner, but I retaliate.
Wow. I'm showing you what's been marked as exhibit number 6. Can you see it?
I sure can.
What is it?
It's a notice of bond forfeiture.
And whose name is on there as a defendant?
That's mine.
And you were convicted of bond forfeiture on December 28th of 2018, correct?
No, that's incorrect.
Does that form not say the conviction date?
Yes, but the form is incorrect. I've never been...
Okay.
The date might... I was not in town on December 28th, 2018, so I couldn't have been convicted of any offense on that date.
A judgment nisi was filed against you, correct?
Yes, I don't recall what date it was filed.
Tell me what a judgment nisi is. Tell the viewers at home what a judgment nisi is.
A judgment nisi is what's filed when someone fails to appear for a hearing and their bond is deemed forfeited, and typically what would occur after that happens is a proceeding would be filed in a county court at law.
So you were accused of failing to appear, correct?
Not criminally, but my bond was forfeited.
Objection as to response. You were accused of failing to appear, yes or no?
Yes.
And in fact, you were found guilty or liable in that judgment nisi, correct?
Liable, yes.
And your bond was forfeited, correct?
Yes.
So why didn't you show up for court?
You want to know why I didn't show up for court?
Absolutely. We're all sitting here at the edge of our seat to hear your response, Jason.
Because I had planned that hunt to Alaska for over 3 years, and I was going to be goddamned if that was another thing that you took away from me. That's why I didn't show up.
This was for a court hearing in your criminal case, correct?
That is correct.
And who is responsible for setting court dates in criminal cases?
The court.
Not Tom Retzloff, though, right?
No, but as you recall, I can tell you why you were responsible for that, but you don't want to hear it.
Tom Retzloff is not in charge of the Denton County court system, is he?
Not officially, no.
You think unofficially I'm in charge?
I think you've exerted a great deal of influence over the Denton County District Attorney's Office with respect to cases involving me. Yes, I do.
And you knew about this court hearing in December, correct? Yes or no?
At one point I did. I don't recall when I learned about it.
Okay, but you knew you had an obligation to show up in court on a certain date, correct?
Yes, the original date I was told was January the 6th.
Whatever. You were supposed to be there in December.
That was later changed, yes.
And you didn't show up. You were in Alaska, right?
That is correct.
If you've been an attorney for 12 years before you got hit with the ban hammer, have you represented clients in criminal cases?
Yes, I have.
How many?
I don't recall exactly. I'd say over 200, less than 500.
Have you ever advised a client not to show up for a court hearing?
No.
And in fact, you always advise your clients to make sure they show up for court hearings, correct?
That's correct.
And it doesn't really matter what the excuse is, you got to show up, correct?
That's the law. Yes, it is.
And you failed to appear, correct?
That is correct.
I'm just getting warmed up. Yeah, giggle there. All right, I'm showing you what's been marked as exhibit number 7. Can you see it?
I can.
What is it?
It appears to be an announcement from a fraternity known as the Proud Boys.
And what is it that they're announcing down there in yellow that's been highlighted?
As I told you, I am not answering any questions concerning the Proud Boys.
What does it say down there in yellow highlight? That's not a valid objection.
Fine.
You know that.
All right, we hereby announce that the duly elected chairman of the Proud Boys Elders Chapter is J.L. Van Dyke, 4th degree brother.
And is that at the time when this press release was issued, was that a true statement?
It was, yes.
What does it mean to be a 4th degree brother in the Proud Boys?
That means that you have made some type of material sacrifice or for the because of the brotherhood.
And how many degrees of membership are there in the Proud Boys?
Well, right now there's 3 because my understanding is that the 4th degree was abolished.
I'm saying at that time, how many degrees of membership were there in the Proud Boys?
There were 4.
4. What does it mean to be a 1st degree member?
A 1st degree member has to state his intention to join the Proud Boys by reciting in a public manner, typically on a video posted to social media, as follows: I am a proud Western chauvinist and refuse to apologize for creating the modern world.
What is number 2? What is the 2nd degree?
The 2nd degree is typically completed. It's called punching in. It's a person is surrounded by approximately 5 other brothers, plus a guy who is counting. He recites the creed that he recited for the 1st degree again. He is asked if he understands what's about to happen to him, and he is told, he is confirmed that we typically say, you understand we are not trying to hurt you, but you very well might get hurt. Do you understand? And upon receiving an affirmative response, he recites the creed, at which point the counter will say, you will now name 5 breakfast cereals. The other 5 brothers will start punching the person above the belt and below the neck until he recites 5 breakfast cereals or is unable to continue. And it's up to the counter to make sure that that nobody gets carried away and that everyone stops once he reaches the 5th breakfast cereal.
what types of breakfast cereals? Any kind of breakfast cereals, right?
Yes, any kind of breakfast cereal.
All right. So tell me what a third-degree member is.
Someone who gets a tattoo having to do with the Proud Boys in some manner.
And you've got such a tattoo, correct?
I do.
And what's a fourth-degree member?
As I stated previously, a fourth-degree member, that's an honor that is conferred at the discretion of the elders chapter or a person's particular chapter. It can be any type of sacrifice or confrontation in the name of the Proud Boys.
Would that involve an act of violence?
It can, at times it has involved acts of self-defense, which, yes, can by their nature be violent.
And how did you earn your fourth degree, Jason?
I was, me and some other fraternity members were jumped outside of a bar in Austin, Texas. A person started a fight, and I physically defended myself and other brothers.
Was a police report filed?
We called the police. I don't know if they made a report.
And when did this happen?
In March of 2018, I believe.
And this was in Austin on 6th Street.
I don't recall if it was on 6th Street, but that's about where it was, yes.
Are you familiar with a website called officialproudboys.com?
No.
You've never heard of the website officialproudboys.com?
Yes, I've heard of it, but I haven't accessed it in about a year and a half, so I don't have any idea what's on there right now.
Dude, that's not what I asked. I asked, are you familiar with a website called officialproudboys.com?
If you're asking if I know that it exists, yes, I know that it exists.
Okay, that's all I want to know.
Okay.
Who is Damian Bates?
No idea.
In an October 5th article, October 5th, 2017 article in Proud Boys magazine, member and author Damian Bates describes fourth degree membership as getting into street fights with Antifa. Who is Antifa? A-N-T-I-F-A. Who is that?
They are a loose collective of left-wing domestic terrorists.
And this fight that you got in Austin on 6th Street, did that involve members of this Antifa group?
It did.
And how many people were involved in this fight?
I'd say there were approximately 8 of us and 15 of them.
8 of you and 15 of them.
Approximately. I don't recall the exact number, Mr. Retzloff.
Okay. And for that, you got your fourth degree, correct?
Yes.
I'm showing you what's been marked as exhibit number 40. Can you see it?
I can.
What is it? What do you see?
I invoke my Fifth Amendment privilege and refuse to answer on the grounds that I might incriminate myself.
On the basis of what?
On the basis that identifying this photograph or discussing it could lead to me incriminating myself for an aggravated assault. I refuse to answer.
Is that a photograph of you on 6th Street in Austin?
I invoke my Fifth Amendment privilege and I refuse to answer on the grounds that I might incriminate myself.
What are you holding there in your right hand in this photograph?
I invoke my Fifth Amendment privilege and I refuse to answer on the grounds that I might incriminate myself.
That looks like a knife. Is that a knife in your hand?
I invoke my Fifth Amendment privilege and I refuse to answer on the grounds that I might incriminate myself.
It appears that you're running in that picture. Is that correct?
I invoke my Fifth Amendment privilege and refuse to answer on the grounds that I might incriminate myself.
Does this appear to be a photograph taken in a public place on a public street?
I invoke my Fifth Amendment privilege and I refuse to answer on the grounds that I might incriminate myself.
In March of 2018, were you licensed as a lawyer by the State Bar of Texas?
Yes.
And in what other jurisdictions were you licensed to be a lawyer at in March of 2018?
Washington, D.C., Georgia, and Colorado, if memory serves me right. I might have done Washington, D.C. later. I don't remember at what date I got licensed in Washington, D.C. and Georgia. It was around that time. I'd have to look it up.
And it was only just 1 year prior that you had applied for a job and got hired as an assistant district attorney in Victoria County, correct?
Correct.
Would you not agree that people that get employed as prosecutors should be of good moral character?
Yes, I do.
And would you agree or disagree that people with extremist beliefs should not be hired for such jobs?
I disagree with that.
So if a person was a member of this Antifa group and they wanted to be a district attorney, you'd be cool with that?
No, I wouldn't be cool with that, but you said extremist.
Why not? Why not? Why not? Why wouldn't you be cool with a member of Antifa being an assistant district attorney?
Because they're domestic terrorists.
Who says?
The FBI, for one.
Okay.
Members of Congress, for another.
Okay. How about a member of Greenpeace? Could a member of Greenpeace be an assistant district attorney?
I think that would be fine.
How about a Nazi? Could a Nazi be an assistant district attorney?
No.
How about a white supremacist? Could a white supremacist be a prosecutor?
No.
And what about a person who has posted comments on social media that people would consider racist? Could they be an assistant district attorney or prosecutor?
Absolutely.
They could?
That's the answer to my question.
Why? Why do you think that would be okay?
Because no one knows what the hell the definition of racist is today.
If you call someone a nigger, would that be racist?
And I think it would depend upon the circumstance.
Tell me a circumstance when you think it would be okay to call someone a nigger.
Well, let's say, for instance, they've just posted your social security number and those of your mother and father on the internet and encouraged everyone to rob them of their retirement savings. That might qualify.
Who would you be calling the nigger?
The person who did it.
How do you know that they're black?
You're talking about a hypothetical.
I'm showing you what's marked as exhibit number 59. Is that your Twitter account?
No, it's not. I don't have a Twitter account right now. Actually, no, I do have a Twitter account right now. I don't have that Twitter account right now.
Did you have that Twitter account on December 29th of 2014?
Yes, I did.
And read off to me what that says there on that tweet. Starting right up here. Right up here.
Object to form. I don't hate black people, I hate niggers. There is a difference, and at I can't pronounce that. Dividedly is a nigger with a capital N. That's what it says.
And you wrote that?
I invoke my Fifth Amendment privilege and refuse to answer on the grounds I might incriminate myself.
Incriminate yourself? For what? What sort of crime?
A federal hate crime, for one.
Calling someone a nigger is a federal hate crime?
Potentially, depends on the circumstance.
Okay, the circumstance from exhibit number 59.
I don't see that on the screen.
Well, it was just up there. What, you forget already?
I didn't know what exhibit that was, Mr. Retzloff.
Okay. All right. This exhibit right there. You're saying that this could be a federal hate crime?
Potentially, with the kind of prosecutors we have working today, I think it absolutely could be.
What's the statute of limitations for federal offenses?
I don't know. I don't practice federal criminal law.
How many fingers am I holding up?
Object to form 5.
5 years. And this tweet was dated when? Again, what's the date on that tweet?
It looked like 2014. Okay, 29 December 2014.
Yeah, so that's more than 5 years ago, right?
Yeah, it looks like it.
Yeah, okay. So tell me again, you wrote that,
I wrote
correct?
that. All right, fine, yeah.
And did you have any personal knowledge that the person that you were communicating with on there was in fact a nigger?
The profile picture was a picture of an African American man.
Okay, so? What the hell's that supposed to mean?
Is there a question there?
I'm showing you what's been marked as exhibit number 58.
Okay.
Read it to me.
Right
here.
It says, I don't waste my breath on niggers like you, I hang them.
What did you mean by that?
I was intending to threaten physical violence against a person who had posted my social security number and those of my 2 parents publicly on Twitter and encouraged everyone to rob us of our money and our retirement savings.
Did you call the police?
Yes, I did.
Which police department did you call?
At the time, I called the Secret Service.
The Secret Service. Like they're supposed to care about what somebody says on Twitter?
Mr. Retzloff, the Secret Service is responsible for the prosecution of federal financial crimes. They clearly had jurisdiction over this. They referred, to the best of my knowledge, they referred the case to the FBI, and from the best of my memory, I got a call from an agent with the FBI, and they said that they're not going to do anything about it because Twitter had suspended both users.
Okay. But you're complaining, though, that these dudes were, like, stealing your identity and such, right?
Well, they did, and I couldn't get the police to do anything about it.
So your response is to go on social media calling people niggers and threatening them with violence.
Object to the form. That's a harassing and abusive question. I'm not going to answer that, Mr. Retzloff.
You didn't threaten to hang them?
Mr. Retzloff, I'm not going to warn you again. You're asking abusive and harassing questions. I've been very patient with you, and we are well outside the scope of discovery in this case.
This case is about you making threats of violence. I'm showing you what's marked as exhibit number 57.
Okay.
Read the highlighted stuff.
Not as mad at Talib is going to be when I personally skin him and have his hide put on display in my living room.
And who is Talib? Who is this Talib you're referring to?
He's a wannabe gangster rapper named Talib Kweli.
Okay. And why would you want to skin him?
You mean, let me think here. Because he assembled a Twitter lynch mob against me to mess with my firm's social media pages. He got people to call the martial arts gym where I was practicing and get me expelled from there. And he sent several people to my house that I had to call the worthless Oak Point Police Department on.
people actually showed up at your house? That's what you're claiming?
They did.
How many people?
About 4.
When?
That would have been in around November of 2017, about before Thanksgiving, if I recall correctly.
And you reported 4 people coming out to your house to the Oak Point Police Department.
I called 911. I'm assuming it went to the Oak Point Police Department.
Did a police officer come out to your house?
No, because while I was still on the phone with the police department, they left.
So, I've shown up at people's houses before after the suspects have left. I was a police officer for many years. I always showed up. You're saying these guys didn't?
I told them when I saw them leaving, because I had a rifle trained on them through my window, and when I saw them leaving, I said, they've left, I don't need your help now.
Oh, okay. So the police just took your word for it and they just decided not to come out.
I don't know. I told that the 911 operator, as I recall, asked me if I still needed someone to come out, and I said, no, they're bugging out.
Okay, all right.
If you enjoyed this video, please subscribe, give this video a thumbs up, and press the notification bell. Additionally, you can view our playlists and most recent videos. Thank you for watching.